The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Thank you. Good afternoon. Good afternoon. Our first case for this afternoon is 2020-60465, Jeffrey K. Davis versus United States Marshals Srv et al. We will begin with Mr. O'Donnell.
Thank you, members of the court. I appreciate the opportunity to be here this afternoon. Although the Zoom platform is new to me, so I hope there aren't any glitches or anything that we can't overcome this afternoon. I'm sure things will work out fine. But
we can hear you perfectly and see you very well.
Excellent, thank you. Although I do miss the opportunity to be in New Orleans, so another time. So on behalf of the appellant and plaintiff, Jeff Davis, I'm David O'Donnell. And in this case, Your Honors, we have an issue of pleadings. It's an issue of whether or not the amended complaint in our case stated a plausible claim for breach of contract and due process against the Marshals Srv and two individual defendants, Mr. Harlow and Mr. White, and a related claim against Metropolitan Security, or as we might refer to them today as Walden. They are the entity that provides court security services under a contract with the Marshals Srv within the Fifth Circuit. So as a pleading issue, in terms of whether or not the complaint states a plausible claim for breach of contract and due process in this case, the review on the front end is de novo, so there's no deference paid to the district court's decision. But number two, under the Iqbal Twombly standard, the facts are treated as true, and any reasonable inference within the facts related in the amended complaint is to be indulged in favor of the plaintiff, Jeff Davis. So in this case—
what errors do you believe that the district court made?
Well, Your Honor, I believe if we talk about the breach of contract claim, I think the court was wrapped in an analysis of whether or not Mr. Davis had standing under the contract between the Marshals Srv and Walden. Did not address subject matter jurisdiction, which the court, I'm sure, will have questions about this afternoon. Those are questions that the court can take up sua sponte, as the court is well aware, but became, I think, confused about whether or not Mr. Davis has standing. And I think our arguments with regard to whether the Marshals Srv and Walden are joint employers is, I think, our strongest argument as far as whether Mr. Davis has standing to raise the elements that are provided in the Walden Marshals Srv contract in terms of raising his claim for breach of contract. And then ultimately, of course, his due process claim.
Now, just so a number of these Marshals Srv claims involving, there were a whole series of them involving hearing loss tests a few years ago. So there are a lot of them across the country. And some of them have to do with, and there's a union involved. Is there a union involved in this one that's pled, or is they're not the union in this one?
Judge Elrod, no, there's no union. There's no collective bargaining agreement at stake in this case.
Okay. And that's what I thought, that was a difference between this and some of the other ones. Is Ruiz versus Mukasey your best case for the idea that it's a joint employer, or what is your best case?
Well, Walton and Ruiz are both cases that we would rely on. There's a series of cases, as the court's probably aware, concerning that very issue in different contexts, although I believe that the contexts themselves are not material to the issue here. That is, can a joint employer test be applied in this case? I think clearly it does have application. I think it's any of the analysis presented in any of the Rehabilitation Act cases or ADA cases or Title VII cases, which have considered whether the Marshal Service and their contract security agency are joint employers, is equally applicable here. We have the same elements.
Can I back up just a little bit? The nature of the contract, or the employment agreement, I should say, between Walden and Mr. Davis, is that any type of written contract, or is he an at-will employee of Walden?
Your Honor, there is a letter that went out to Mr. Davis from Walden when he was initially offered employment. That letter contains the terms of Walden's perspective that Davis's employment would be at will. Okay, so it's a form letter that went out. There's nothing else in terms of writing it that it might explain or delineate the terms of the conditions of his employment with Walden.
One more question along those lines. Is there anything that suggests that his placement in the position that this litigation is about, is there anything to suggest that his placement was conditioned on the official approval from whoever at the U.S. Marshals Service? I should say anything in writing or formalized?
Yes, that same letter, Your Honor, states that Mr. Davis's employment would be subject to the approval of the Marshals Service. And that's what we believe also supports and brings in the contract between Walden and the Marshals Service, because that is every bit germane and material to the conditions of Mr. Davis's employment. You know, how he
theoretically, I realize this may not be what's not in the briefs, but theoretically, I don't know anything about Walden's business, but he could work for Walden, but not in this position that the Marshals Service would have any approval for. Is that correct also? In other words, he could be placed somewhere else in the employ of Walden, but not in a position that involves the Marshals Service.
Practically speaking, I don't think that was the case. I think doubly so with regard to the adverse suitability determination. I think that foreclosed Mr. Davis from any meaningful employment. So there's no evidence or record of that at this point.
As to, I got a question about your due process claim.
Yes, sir.
Which specific defendant or defendants are you bringing that against?
We're bringing against both David Harlow and Thomas White. As the amended complaint relates, I'll try to hold my comments about what happened in terms of what's alleged in the amended complaint, but it states that Mr. Harlow and Mr. White were both instrumental in that process of denying, terminating Mr. Davis's employment, and ultimately denying any explanation and refusing any explanation when Walden and Davis both requested some form of explanation. I think
quick question. So Harlow and White, they're both federal employees, right? Federal officers.
Yes, sir. Harlow is the acting director, and Thomas White was the acting assistant director of the Office of Court Security.
I asked because your complaint says, the due process claim is brought under 1983 and under Bivens, but regarding the 1983 claim, there are no state actors here, right? There are just two federal actors.
That's correct, Your Honor.
That's the due process claim, correct?
That is correct.
Okay, so you would concede there's no 1983 claim against Harlow and White.
I do concede that. I think that reference was included as a matter of how how a court would approach a Bivens claim would be in the same nomenclature elements that a 1983 claim would be looked at. So, but yes, the court's correct.
What specifically would you like us to hold today?
Well, what we'd like, our requesting is that the court remand this case, allow us to conduct discovery, allow us to ask the Marshals Service why. We think the contract between Walden and the Marshals Service gives Mr. Davis that contractual right to know why he's terminated. I mean, he was in fact hired. He was in fact terminated. There was some dance in the briefs before the district court about whether Mr. Davis was actually hired. He clearly was hired, as the amended complaint alleges. We're talking about 12B6 standard, but there really is no genuine issue if we were talking about a summary judgment issue here. But he was hired and then terminated without explanation. And there's two provisions in the contract, the suitability provisions and section H.9. It gives Mr. Davis the right to be told why, and then to be given an opportunity to contest why. Those are valuable contractual rights, and he was not permitted that opportunity. And if we refer to the aspect of the appeal that gets into the motions to compel discovery, a subsidiary issue, but an important one because it illustrates the links to which we ask why and the links to which the Marshals Service refused to say why. And I would point out as well in this point that Walden asked why. We don't take issue with Walden because it asserted the right to know why, and it was stonewalled just like Mr. Davis was. So we ask for the opportunity to know why. Give us the opportunity to be heard.
Quick question about your Bivens claim. I mean, as you know, the Supreme Court has allowed kind of Bivens liability in 3 and only 3 circumstances. And can you explain why this would not be extending Bivens to a new context?
Well, that is a difficult question for me because, again, the standard about allowing a Bivens claim, as the court's well aware, is a difficult one to achieve. But there are a number of cases. There's a few cases that we've cited in our brief about whether a Bivens remedy would be available. And that is, does Mr. Davis have the right to pursue a procedural due process claim against the Marshals Service? Or in this case, given the 11th Amendment immunity against the 2 individual defendants. I think that right is there. I don't think it's an unusual right. So therefore, under the Ziegler case, we don't fit within it's just a new case. It's a procedural due process case. I think the Passman case is sufficiently analogous, but there are other cases subsequent to that decision that do talk about and provide that remedy, and specifically in the Marshals Service context, cases brought by CSOs for the denial of a due process right. So,
I'm sorry, go ahead. So, I finished answering Judge Willett's question.
So we would say that it's not a novel case, but if it isn't a novel case, then we would say that given the complete absence of alternative remedy to Mr. Davis, that he's left with a due process claim here. And I think therefore there's no special factors that would counter the allowance of a due process claim for Mr. Davis. And I think that's how the Ziegler criteria are set up, or at least explained in that case. There's nothing that would suggest that it would be inadvisable for the court to extend a Bivens remedy in this case.
Mr. O'Donnell, assuming that we agreed with you, arguendo, that they were joint employers, I'm not sure it gets you anywhere. I mean, the district courts seem to think it didn't get anywhere. Because, I mean, if this were a retaliatory discharge claim under the employment laws, then certainly you could pursue that, but that's not what this is. So I'm trying to figure out, how does the joint employer help you here?
Well, the joint employer helps us because it gives us standing to pursue the contractual remedies in the Walden Marshals Service contract.
Right, but have there been a breach of I guess you've pled it and we should move on because the district court got hung up on the standing and they should go back and look at that. I'm just not sure where you get, because you don't have a retaliatory discharge claim under some whistleblower statute, do you?
Well, of course, the complaint alleges and sets out a separate whistleblower or reprisal claim, but as the pinball analysis has gone for us in the administrative proceedings and then on to the district court, Mr. Davis happens to fit within a very novel and narrow crack there, that he's alleging that he was a former U.S. Marshal and he engaged in whistleblowing activities, and those resolved. He retired in good standing, and he happened to come into a position that the Marshals Service was interested in and controlled as a joint employer, and they terminated his services, we allege, because of his whistleblowing activities. But he's not a member of the civil service. He's not a protected position as far as the statutory whistleblower provisions are concerned. So that leaves us out there, I believe. So,
Okay.
but the joint employer gives us the right to pursue these contractual remedies, gives us standing.
Mr. O'Donnell, you saved time for rebuttal.
Yes, ma'am.
And we will now hear from Ms. Lopez.
May it please the court, Carolyn Lopez on behalf of the federal defendants. I want to make sure that I'm addressing each of your honor's questions, particularly with respect to the breach of contract claims and the Bivens claims. I think the fundamental defect here that plaintiff can't get around is, as your honors pointed out, this case is very different than some of the Rehab Act cases. Here, the contract that he had directly with his employer said it was an at-will contract. And what he tries to do is get around that at-will contract, which really gives people very little rights, if any, particularly where it's further contingent on additional approval. And what he tries to do is piggyback off of a federal contract for the procurement of services that's between Walden and the Marshals. And he's just not a party to that contract. And as we explain in our brief, that's actually a fundamental subject matter jurisdiction problem, because it is a CDA contract, it's actually only the contractor who has whether one calls it standing to sue, as the Second Circuit explains, and in its case, Atterbury, which involves some of the very same provisions in Marshals contracts with security service contractors, or whether you think of it as the CDA says only a contractor is able to sue, and therefore the United States hasn't waived its sovereign immunity with respect to claims brought by contractors' employees. And so
Ms. Lopez, can you help us though? What if this causes some discomfort? And sometimes the law does cause some discomfort. So that's not always a winning argument, that discomfort in itself. But the fact, what if the Marshals Service, and this is a hypothetical, said we don't want him because of his race, and we get to make the final choice. And so even though you've already hired him, you can't hire him. Where is his remedy there?
So, Your Honor, of course, that is far afield from the allegations here. And here, I do just want to step back for one moment before I get to that to say that here, Congress has specifically thought about whistleblower reprisal claims in two different statutes. So there's the statute that plaintiff erroneously relied on here that's not available to him, which is the one only for covered federal employees. But Congress did actually go back in this context, and we discussed this in the brief. It's 41 USC 4712, and that actually allows for suits directly against the contractor by contractor's employees, assuming that he is actually an employee and not sort of in a contingent offer situation. And that includes for actions taken by the contractor at the express direction of the executive, subject to certain additional limitations.
And so why doesn't that available?
The United States,
he hasn't pled that claim, but to be clear,
did he amend his complaint to plead that claim?
No, Your Honor, he's had ample time. He's already had the opportunity to amend his two responses. The first is that the district court acted well within its discretion here to say that when he had already been allowed to amend his complaint, and that's after here, crucially, the federal government had already filed a motion to dismiss pointing out the
we
various
didn't think it made
jurisdictional
sense
deficiencies
for
with
us
this
all to
argument. So
troop down
both,
Okay,
there for
so
that
what's the
purpose.
answer to the hypothetical?
and then,
things are
sorry,
going to
just
change
to
pretty
close the loop
soon,
on that
I
one
think. So
whistleblower
that's
retaliation
something.
claim, which is the facts here.
We do have a couple of adjustments
There,
or
the remedy lies only against
extra
directly
rules of
against the
the road
contractor, not against
for
the United States. The
purposes
United
of
States has
Zoom
made
hearings. One is we
clear
ask
that it
you to
has not
silence any
sort of
other devices
waivers of
you
sovereign
have,
immunity have to be
or those
clear
of
and
people in
unequivocal,
the
and here
room
it's
with
just the
you.
opposite. The United States,
Second
Congress
one
has
is
thought about
that
this quite a bit
we
and hasn't provided a
still
remedy.
do
And
the
so,
audio
Okay, can you answer my
recordings
hypothetical? Ms.
absolutely, Your
sitting,
Honor.
but
And
we
with
will
respect
not-
to a
we
racial
do-
discrimination claim,
As
you
in
know,
New Orleans, you're not allowed
not
to
his
video
attorney. I can't,
audio
you know,
them
those are
for
not.
No,
yourself.
I'm asking
his attorney.
But
is
if
there
you
a
like,
provision-
we will give
Can
you
Walden be
5
liable
minutes
if they
uninterrupted
didn't
time
if
at the
they took
beginning of
away
your
his offer
presentation,
because
just
the
because there's
Marshals
always a little
Service
bit of a
said
gap in
don't hire him
communication
because
here.
of his race?
And then
Or
the other
could the
thing I would
Marshals
say
Service
is we
be
will
liable
appreciate in
as a joint
both of your
employer or
cases, record
otherwise in that
citations.
circumstance?
Your Honor,
Um,
any
we
remedies
have a
that he
time
may or
clock
may not
system.
have
The
for
yellow
this
light
instead a
will
racial discrimination case
tell you
would
that
be
you
under
have 2
Title
minutes
VII
left,
in
and
the
when the
Rehab
red light
Act.
signals,
And for the reasons
we
that
ask you
we
to conclude
described in
unless you're
distinguishing,
answering
for
a question
example, his
from the
joint
court.
the cases
The
cited on
sole
the
case
joint
this
employer
afternoon
theories,
is number
those contexts are quite different
220416.
So could they be
Polyflow
liable under
versus
Title
Specialty
VII as joint
RTP,
employer of
and
the
we'll hear
Marshals
from
Service in that
Mrs. Stratton
circumstance?
to begin.
Your Honor, I can't, standing here
Thank
today,
you,
get
Judge
out ahead
Jones,
of the
and may
United
it please
States
the
and say in a
court.
hypothetical case
The
in which
parties'
in
contract
which
says
there are
that any
accusations that the United
action
States
arising
was
out of the
liable
agreement
for sort of
must be
somehow
arbitrated.
interfering with an employment
In this action,
relationship in which
Polyflow
the United
alleges that
States was not actually
appellees
the person's
breached
employer.
the agreement,
I can't stand
giving
here
rise
today
to
tell you yes
various
or no that
contract
the
and
United
tort
States
claims.
would think that it had
But
waived
the
its sovereign
district court
immunity
denied
through
Polyflow's
Title
arbitration
VII or the
request.
Rehab Act for
This court should
plaintiffs
reverse for
who
2
are not
reasons.
the United States employees.
First,
But we
because
have
the
a lot
parties
of cases in
undisputedly
the
have an
rehab
arbitration
context,
agreement, the
especially
law
these hearing
heavily
cases
presumes
that
that
were
Polyflow's action is
popular for
arbitrable.
several years.
To deny
where the
arbitration,
U.S. Marshals
this
Service
court must
was
have positive
liable, right?
assurance that the arbitration agreement
yes, Your
cannot
Honor,
be
there have
read
been
to
some
cover
cases.
this action.
There have
There
been
is
some
at
cases
least
in
no
which
such positive assurance here.
they did, but most of
Second,
those cases actually were
appellees' merits
ended up being
defenses and
dismissed on other
procedural
grounds. For example,
arbitrability challenge
I
are
apologize,
for
I
the
forget the name of
arbitrator
the
to
DC Circuit
decide,
case, but
and thus may
the DC
not
Circuit
preclude
case that talks
arbitration.
about this, for example, actually doesn't reach
To
the joint
begin,
employer.
the scope of the arbitration agreement
often
here
courts
is
don't actually
reasonably
reach the
construed
joint
to
employer.
cover this
Ruiz
entire
versus
action.
McCasey from our own
The
Southern
settlement
District of
agreement
Texas most
requires
explicitly
arbitration of
did.
any action that
Yes, Your Honor, and
arises
I
out of
do
the
want
agreement.
to, turning to
The plain
Ruiz,
meaning of action
Ruiz does
is
not stand for the
lawsuit,
proposition
the entire
that
civil proceeding.
even in the Rehab Act
So
or the
the
Title
parties
VII
agreed to arbitrate
that
the
somebody
entire
standing in
civil
plaintiff's
proceeding if
position,
it
which is a
arises out of the
contingent offer
settlement
to be a
agreement.
completely different
And
type
this
of
lawsuit
employee.
qualifies.
So here, and there
First,
are
this
a number of
lawsuit
district court
exists
cases
because
that
of
we
the
cited in
settlement
our brief
agreement. And the first
that have
page of
concluded
Polyflow's
that
complaint
where what we're talking
at
about is a
1189 of the record on
supervisor
appeal makes that
position.
clear,
That's
stating
different
that
than
Polyflow
these
is
CSO
bringing this
positions
action
because the district
because the parties
supervisor
entered a
position
settlement agreement,
under the terms
but
of the
appellees have not
contract,
complied
and
with
that's
it
in
and never intended to comply.
3.4.1
Second,
of the
this
contract.
lawsuit
It
includes
expressly
claims that
provides that the
appellees
district supervisor
concede
is, quote,
arise
the
out of the
primary
agreement,
point of
specifically
contact for the government.
Polyflow's
So
claim and
there, under
appellee's
the terms of the
counterclaim
contract,
for
quite
breach
clearly
of the
Walden's
agreement.
representative to the
So
Marshals. So
because
regardless
this
of what
action
one
unequivocally
district court
includes
thought
claims that
about
arise out
whether
of the settlement
other types
agreement,
of
and
employees who
indeed,
are not
the
specifically
lawsuit only
identified as
exists
Walden's
because
point
there
of
is a
contact
settlement
and in
agreement
that
that we
same
allege
contract
has been
term
breached,
who have authority
the
to make
action
personnel
arises
decisions
out of
on
the
behalf
agreement.
of
And
Walden,
the
not
plain language of the
the US
arbitration
Marshals.
clause thus
Those types
requires
of employees
arbitration
certainly
of
are
the
not
entire lawsuit.
are not
And this
the
court
Marshals
employed
employees
that
for purposes
reasoning
of inferring
in its
liability. And
2019
again, just to bring us
decision
back
in
to the
Archer, which we
context,
cited to the court as supplemental
here,
authority. The
Congress
Archer panel
has not only
focused
not
on the plain
unequivocally
meaning
waived
of the
its sovereign
term action,
immunity with
which
respect
meant
to
the
whistleblower
entire
retaliation
lawsuit,
claims, but
not
has
just
in fact
individually
thought
qualifying
quite
claims.
hard about them and set up
And it
two different
refused
statutory
to
schemes
rewrite the
that
arbitration
create different
agreement
types of
there
liability.
to encompass encompass only individually
So
qualifying
this court
claims.
just need not
And I
reach
think
that
it's
other
important to
question here.
note
But again, we
that
do think that there are
the
multiple
reasoning that Archer used
distinctions
applies
there.
with even
So
more
just to
Should we be
force in this
concerned
case,
that
because
that
there,
they
Archer
could
involved
blackball
an exclusion from
people that
arbitration.
make
So the plain
whistleblower
meaning of
claims from
action, the
future
exclusionary
retirement
language, had to be enough
employees
to
as
overcome
CSOs that
a
is very
presumption in
valuable
favor of
to
arbitration.
many former
Here,
employees
the
of all
plain
kinds
meaning of
law
any
enforcement.
action governs what is included in
Your Honor,
arbitration.
both
So
because
in
there's
this
no reason
case,
to sort of
the contract's plain
infer
language
that anything like
and the
that has
presumption
happened
in
here, but
favor
more
of arbitration
complaints would
are
have said.
rowing in the
but
same
more
direction.
fundamentally, well, the
And I have
complaint-
to take it as true.
Appellees have contended
So,
Your Honor,
that
but
a
actually, I
settlement
mean,
agreement
even if we're sort of talking about,
deviates from
Your
the
Honor, of
plain
course
meaning
not.
of action,
But even
and
once
specially
we're sort of
defines
talking
action
about
to
the
more
Bivens
narrowly mean
claims where
only
he's
claim.
making specific
But the
allegations, I think
contract
there it
does
actually
not
really
support that
highlights
argument.
exactly why as the district
You can
court
see the
concluded
settlement
there with
agreement at
respect to
tab
individual
4 of
liability.
our record
Even the
excerpts.
complaint
And if you
doesn't
look in
satisfy
subsection
what one
A
has to do,
on the
even
very
at the
first page, you'll
allegations
see that the settlement
So
agreement does not define the
here,
term action.
yes, plaintiff
So under
identified
ordinary
one
contract
person,
interpretation
Chief Deputy
principles,
Kelly
the
at
plain
US
language
Marshals
of the
Service, and
term
this is based on
should
his own
govern
complaint.
lawsuit,
One
entire
person at the
civil
US
proceeding.
Marshals Service,
What
who
the
he says
settlement
retaliated
agreement does
against him.
define at
He then
A1
says
is
he
the
brought a
term
number of
claim.
complaints about
And it
that
defines
person to the
it
US
because it's going
Marshals,
to
and that the
use that
US
term to
Marshals, in
describe what
fact,
is being released by the parties
concluded
in
they
this settlement
sided with
agreement
him
and
in every
released.
one of those
So it
complaints.
defines
After
claim
that,
expansively
not only was he not
to include
fired from the
not
US
only
Marshals, but
claims,
according
but
to his
also
own complaint, he
demands,
was actually promoted.
actions, causes
And
of
after he
action, so on and
retired
so
from the
forth.
Marshals,
All
again,
that this
according to
means,
the
however,
allegations
is
of his
that
own
when the
complaint,
settlement agreement
other
uses the
people
word
at the
claim,
Marshal
it
Service
means to incorporate a more
reach
expansive
out to him
meaning.
to tell him
It
about
does
this
not
position.
mean
There's
that when
simply
the
no
settlement
basis,
agreement uses the word
even
action,
within
as it does in this
just
arbitration
taking-
Except he
agreement,
says it.
that
We
the
have to-
parties intended to more
revenge is
narrowly
a dish
constrict the
best
plain
served
meaning of that
cold.
term to mean
The
only
person
claim.
had the,
And in
the
fact, Your
power and
Honors,
the authority is what's been alleged.
A1 of the
And we
settlement
need
agreement
some
that defines
discovery to
claim
see if
shows
that
the
actually
parties
happened or
understood
if it's
that there is
some
a
far-fetched
difference
theory.
between the word
No,
action
Your
and the
Honor,
word claim
for
because they
multiple
define
reasons.
claims to include
There
claims,
the
actions,
district court
and causes of
had
action, showing that they understand the
lacked
difference.
subject matter jurisdiction over
So
the claims he
we
actually brought.
contend,
And I do just want to
with the
bring us
support of
back
Archer
to that, because
and other
regardless of
authorities,
whether or not the
that
court
this any
might
action
think
clause
in some
is
other case there's some
unambiguous,
sort of
and the
lurking
entire
unfairness
lawsuit
here,
must be
that's
arbitrated.
not a reason
But that is
to
at
craft
least
a
a
new judicial
reasonable
remedy,
interpretation
whether we're talking
of
about
the
crafting
arbitration
some sort of
agreement.
new breach of
And so in
contract
that
claim
case,
for
the
which the
standard for
United States
denying arbitration is
hasn't
not
waived
met
its sovereign
because
immunity,
this court can
whether
have
we're
no
talking
positive
about
assurance
recognizing
that
a
this
new
agreement is
Bivens cause of
incapable
action
of being
in
read to cover
a situation
this
that
action.
is both markedly different from
I'd like to
circumstances that have
turn
been
now,
recognized
unless the
before,
court
and
has
would and
questions
have
about the scope of
as
the
in contu
arbitration
a
clause,
legion of special
to
factors
appellees
counseling
asserted defenses.
against recognizing that.
Let me ask you one question. When you say
And
arbitration
so,
clause,
if I might,
the settlement
unless Your
agreement has two
Honor would like
paragraphs
to
discussing
continue
arbitration.
discussing the breach of
Are you
contract
referring
claim, you know, for the reasons we stated
B5C
in the brief,
or C4,
he simply,
or
the
how
district
are
court
we
simply didn't have
supposed to interpret those
subject
provisions
matter
together?
jurisdiction over that, whether that's because
C4 is the
it's actually a
clause that
CDA
I'm referring
contract,
to.
and so
Polyflo's position
contractors
is
and
that
employees can't
based on the
actually
text
sue
and
under that
context of
contract.
the settlement
He
agreement,
did,
that
I mean, to the extent
C4
that he tries
is
to
the
raise a little
arbitration
Tucker Act
clause.
claim now, it's not even in his
B5C
complaint, again,
is,
even after he had the
is essentially
opportunity to
belt and
amend the
suspenders.
complaint,
It's
and the
additional
United States
language that
pointed out
also
that jurisdictional
underscores
defect.
the broad intent of the parties to arbitrate
Plaintiff
a
has essentially
broad
conceded
range
that he
of
doesn't have a
disputes.
claim
And
under
so
the
when I'm
whistleblower
referring to
statute
the arbitration
under
agreement,
which
I'm
he
referring
relied,
to
and so
C4,
that leaves us
but
with the Bivens
B5C,
claim.
as we've argued in our
And
brief,
here we really
is
think
further support
that the
for
court should
the
affirm
argument that there's
the
no
dismissal
positive
against,
assurance
you know,
that the
these
parties
two
agreed to
individuals who are
exclude any
being
of the
held
claims
under,
in this
you know,
action.
individual liability, and either under
Okay,
the
thanks.
ground that
I'll turn
no
now to
Bivens action
defenses.
should be recognized in this
This court should
circumstance,
hold that the
both
issues
because it's
of
markedly
release,
different from
prior
Davis
material
v.
breach,
Passman,
and lack of
because
mediation
here we're not
are for
talking
the
about a federal
arbitrator to
employee, we're
decide.
talking about a contractor's
This court's
employee,
inquiry,
and then
when
also for the
faced with a
secondary
request for
reason, which is something
arbitration,
that
is very
seems to be
limited.
arising in this
The court does
fairly
not
frequently,
address
that
the
the court has
merits,
not yet
but
ruled
asks
on, but has
only whether an
expressed at least
arbitration
in the First
agreement
Amendment
exists
context would
and whether
probably
the
be
subject matter
inappropriate
of the dispute
for
is
recognizing
within
a new
its scope.
Bivens action,
Where
which
the
is that this involves
existence
claims
of the contract
retaliation, which
is
has the
not at
Supreme Court
issue, as
recognized
here,
in Crawford
The
L are
only
easy to
defenses a
allege
court may
and
consider
hard to
are those that
disprove. And for
specifically
precisely
relate
that
to the
reason,
making of
it's,
the
also a
arbitration
special
agreement
factor for
itself.
weighing against
Defenses that
finding
apply
a new
to the
Bivens cause of
continuing
action
enforcement of the
here. And
contract as a whole
similarly,
or for the
other
arbitrator
factors,
to
as we've been
decide
discussing,
as
is
part
that
of the
Congress has
merits of
thought
the
long and hard
underlying
about this and
dispute.
has
This
repeatedly
court has held that
legislated in
repeatedly
this
in
area. So
Primerica
just like
and
de
Bank
La
One
Paz, the
and
very fact
Willdrill,
that
and the Supreme Court has held
Congress
the
hasn't
same in
recognized
Primerica.
a remedy against
Here, appellee's
particular
defenses
individuals
that
is
Polyflow
yet
has
another reason
sued
actually
on
to
released
not
claims
imply
that
a new
Polyflow
Bivens
has
remedy here.
committed a prior
And then
material
turning
breach
to the district
of
court's
the settlement
rationale
agreement
about
by
these two
firing the
individuals,
neutral pipe
if the court
expert.
were to,
These are not
like the district
independent
court,
attacks that solely relate to the
decide this on
arbitration
whether or
agreement,
not
but
he's
they are
adequately pled
merits
a
defenses
cause of
that
action
go
against
to
the
the enforcement
individuals.
of
He
the contract more
absolutely has
generally.
not. He's
And
pled
Appellee's
two facts
answer
against these
illustrates
particular
that.
individuals.
Their answer in the
The
district
first is
court,
that
which this
one
court can find
individual
at Record
didn't
on
say
Appeal
terminate him. One
1324 to
individual said, please
1325,
suspend
and
his
I
sort of
direct the court
current
specifically to
contingent
paragraphs 3 and 15.
current contingent
Make it
employment,
clear
and the
that
other
they have
person
pled
said
both release
he may not be the most
and prior
qualified
material
candidate.
breach
Now,
as
neither
affirmative
of those
defenses to
two
Polyflow's
statements
claims
come
on the
anywhere
merits,
close
as
to
well
doing
as using
what
both release
under
and
Twombly
prior
and
material
Iqbal
breach
he
in
would
the form
have
of
to do,
allegedly
which is to plead that
firing the
these
neutral pipe
individuals
expert
had some
as a
sort of
basis for their
mandatory constitutional
counterclaim for breach
duty
of
to him
contract.
that they
So
didn't
it's
undergo.
clear from
And
their
here,
answer
that
that
doesn't
these
come
issues, release
close.
and prior material
In
breach,
particular,
these are merits issues
for
for
example,
the arbitrator and not
the
defenses to the making of the
comment that
arbitration
there might be a
agreement
more
for the court.
qualified individual, just
Ms.
looking at the
Stratton, so
record,
let me
appears to
move
be
back
true.
to
The
the
contract
first
requires that
issue
district
for a minute.
supervisors have at least
there,
5 years of
let's
supervisory
assume there's a textual
experience,
argument in
that
the
contract being attached to the
arbitration
complaint, which is why I'm talking
clauses
about it here.
for looking
And
at
based on the allegations in his
your
own complaint, he actually only had 3
complaint
years of
or
supervisory
looking through to your
experience. So it's certainly,
causes
isn't
of
any
action or
indication of some
whatever
sort of
on a piecemeal
inchoate animus
basis.
by
One
either
of
of those two
those
individuals
is
against
fraudulent
plaintiff. And plaintiff,
inducement to
can't
settle.
use a Bivens suit to try and
How
get
do you
sort of far-ranging discovery to
that
say,
with
I have no, that would turn
arbitrating the
Iqbal and Twombly on their
contract?
head to say
And
that
also,
I have no idea.
what about the
I just have a
tortious
suspicion that
interference
somewhere
claim?
out there,
How does
somewhere in the
that
Marshals
arise
Service
out
doesn't
of
like me, despite the
the
fact that,
settlement agreement?
the chronology
So I'll
would
turn first
suggest
to the
exactly
fraudulent
the
inducement
opposite,
claim.
which is that all
It
those claims were
arises out of
resolved
the
against
settlement
him.
agreement for the
According to his
following
complaint, he
reasons.
was also
First,
promoted.
under
He was
Texas
approached
law,
by other
a
Marshals
fraudulent
employees about
inducement
this
claim
job,
cannot
and
exist
to say,
but for the
I get to go on a
fraudulently
fishing
induced
expedition
contract, and it
against the government
requires
to
the
see
existence
whether
of that contract
somewhere,
as part of its proof.
someone
Our claim is
still
even
had
more
animus against him,
dependent
who
upon
had
the
anything to do
contract
with this
because
decision.
in paragraph 80 of our complaint, we allege that it is
If there
misrepresentations
are
in the
no
settlement
further
agreement
questions,
itself
the government
that
asks
fraudulently induced us to
that the
enter the
district court's
contract.
dismissal with
And
prejudice
I'd
be
also
affirmed
direct
for
the
the
court's
reasons stated in
attention
the
to
brief.
the following decisions: Prima Paint, Enrique
Thank you, Ms.
Kaplan
Lopez.
from the
We have your
Texas Supreme
argument.
Court,
We have Mr.
Burwell
Threadgill
from the
next.
Texas Appellate Court, Sweet Dreams from the Seventh Circuit, as well as this court's own
Good
decision in
afternoon.
Marlin,
May I please the
which
court, I'm
involved
Tim
broad
Threadgill on
and
behalf
narrow
of
arbitration
Metropolitan
clauses.
Security,
And
who
the
does
courts held in
business
all
as
of those
Walden
cases that
Security.
fraudulent
So,
inducement claims were
as
arbitrable, whether the
Mr.
clause
O'Donnell
was
talked about,
broad
you'll hear
or
both
narrow.
names, Metropolitan Security and Walden
As for the
Security.
tortious interference claim, Your Honor,
I think
these
first and
claims are
foremost, it's
specifically
important
predicated on
recognize
misrepresentations and
that,
omissions that
we
we
come in the
allege
posture of
appellees
a
made to
motion
third
for summary
parties
judgment
about
having
the
been
settlement
granted.
agreement itself.
The difference
These
doesn't change standard of
misrepresentations and
review, but it
omissions are
does.
pled
I do
at
want
paragraphs
the judges to
64
know
and
that
68
full discovery has
of our
taken place
complaint,
insofar as
and
Walden
they
is
are
concerned.
incorporated by reference into our causes of action at
We're
paragraph
in a little bit
70.
different posture in that regard.
And you'll
The
also
only
find
claim
them incorporated by reference into the tortious
that
interference claim
Mr.
at paragraph
Davis is
117.
pursuing is a
And so
breach
we
of
allege
contract
that the
claim.
breaches of duties
Mr.
imposed by the
Davis,
settlement agreement, the
it's
use of our
undisputed
information,
to Judge Engelhardt's
the
question,
misrepresentation
is
about
it
our
was employed at
relationship
will.
is
He
what
had an offer
caused
letter that
tortious
says the
interference with
office,
business
the
relationships.
offer
And this
is
court has made clear
at
in
will
numerous
employment.
cases, as have Texas
It's not
courts,
intended as an
that a
employment
breach of
contract.
contract
It
can
also
involve
says that it
tortious
is
conduct
contingent
that gives
upon
rise to
approval
both
from
breach of
the U.S.
contract
Marshals
and
Service
tort claims at the same
as well.
time.
And so those
And
are
that's what's
another
happened here.
one of
It's
Judge
why our
Engelhardt's
tortious
questions
interference
expressly
claim
in the
arises out of this
offer letter.
contract
Mr.
because it
O'Donnell and
is
Mr. Davis
generated
don't
by
seem to
appellee's
object to
alleged
that.
breaches of
So
the contract.
what we have, insofar as Walden is concerned,
Do you have
is
any
an employment at will
idea
relationship.
why Judge Hoyt
I've
disposed
thought
of
to myself
this
many times throughout
in
this
one
case,
sentence? And
what are
I'm
we doing in this
looking at the
case?
docket.
Because
It
I've
looks
listened
as
to
if
the
there was
argument,
no
I've listened
oral
to Mr.
hearing
O'Donnell say,
on
we
the
don't take issue with
arbitration
Walden.
agreement. So
But yet here we are.
I do not know.
As far
That's
as,
quite a mystery to us as well.
the contract itself,
Particularly given the
there's
strong
briefing, and
presumption
it's a
in
little
favor of
muddled,
arbitration and the broad
in my
language
view,
here
as
under
to
numerous court precedents.
where Walden stands
So
on
his summary denial of arbitration
beneficiary issue
is quite a mystery
and
to
this
us,
joint
and it's why we're
employer
here.
issue.
I don't know the answer.
As far as a joint employer, I mean, there's no doubt.
I would like to turn and discuss failure of mediation now.
It seems to me that the joint employer argument.
Mediation is a question of procedural arbitrability. And procedural arbitrability is a question for the arbitrator in nearly all circumstances. This court has found that there's only one rare exception in which the court can decide a procedural prerequisite bars arbitration, and that is when it is clearly established that a procedural requirement is a condition precedent to arbitration and has been breached, such that no rational mind could conclude
on the earlier
otherwise.
question.
That
Does
high
Walden
bar
have
for
other
taking
jobs?
this question of whether mediation is a procedural
I'm not
arbitration
aware of
has
other
not
jobs
been
that Walden has
for taking that question from the arbitrator has not
It's a
been
great
met
question.
in
They
this
are
case.
primarily
Because a
security
rational mind
service
could agree with
business. That's what
Polyflow that mediation
do.
is not a condition
They provide
precedent,
security
or
to several
that if it
United
is,
States
it's
courts of
been either
appeals.
deemed fulfilled
I
or
suppose
excused
theoretically
by
there's some
appellee's conduct
administrative
frustrating
jobs because they
mediation.
have people who work
And
in
before
the
I tick through
headquarters
those
who,
reasons very briefly,
working
I'd
an
like to remind the
administrative basis,
court
but other
that
than
under
that,
general
Your Honor,
warehouseman and other precedent,
no, that's their
this court
business,
doesn't
as I
need to
understand it.
Your
agree that
business is
Polyflow
with the
would
Marshals
prevail on any of
Service
these
and
points.
and
It need
and
only
that's who
conclude
they're-
that a rational
It's their
mind
one
could
and only
agree and
client,
that these issues are not
basically. They
clearly
don't have a job
established,
for
such
Joe's
that it's the
restaurant down the
arbitrator's
street to
province to
provide security
decide
to them.
whether mediation is a bar.
Not that I'm aware of.
Mediation is not a bar
And I
and
do
not a
know that
condition
there are
precedent
other,
because it's disfavored under Texas law.
employers that are
And
similar to Walden.
I'd
who also
note that at
provide,
page 30 of their brief,
Like
appellees have
A-Call
reversed course
and
from the
other
That's
position of
exactly
this
right.
court, and they
A-Call is
argued
a
to
big
this
one
court
too.
that
That's
mediation is in
right.
fact not a
Y'all are the
condition
computer
precedent. That seems
competitive
at least
businesses for
suggestive
this,
that a rational mind could agree with
this
Polyflow.
job.
And I'm aware.
The settlement agreement's
correct, and I'm aware
mediation
that a
terms
call has
only apply to issues
services
of B1 and
beyond the
B2
United States
compliance.
Deputy Marshal Service.
They don't
So
apply
that's
to the
why I
other
hesitate to
types of issues that
blanketly
are
say
in
that. But as
dispute
far as
here.
I know, Walden.
And even as to
It's just
B1 and
the
B2,
Marshal
they
Service.
only apply when the pipe expert has made a determination
as
that
the
the
third-
appellees
well,
are out of compliance.
I would simply say
which
this,
appellees
under the
concede never
contract
happened here.
between the government and
But even if
Walden,
it is
which
a
as
condition
Ms.
precedent,
Lopez
it's
said,
been
it's a
deemed
contract between our
fulfilled
two
by their
clients.
failure to specifically
There's no
deny it in
duty
their
in there
answer.
that
But
Walden
even
owes to
more
Mr.
importantly,
Davis, none
it's been
whatsoever.
frustrated
So
by
all of that to
appellees
say,
withholding
from
of their
Walden's
design and
perspective, we've
manufacturing
engaged in
process
full discovery.
information,
We
which is the
did full
earlier
brief
step
for the district
necessary to
court.
even
I've
get
not
to
heard
mediation.
anything in
And this
Mr.
court has
O'Donnell's
held
argument
that a
suggests
promisor
that
cannot
we should
take
have to
advantage
remain
of
in
a
this
condition,
lawsuit.
a
And so
failure
we
of a
ask
condition
that
that
at
they
least insofar
themselves
as Walden's
frustrated.
concerned, that summary
And I see my
judgment be
time is ending, so
affirmed.
I will reserve the
Thank you.
remaining
We
time
have
for
your
rebuttal.
argument, Mr. Threadgill.
Thank you,
Mr.
ma'am.
O'Donnell, you saved time for
We'll hear from
rebuttal, sir.
Mr. Schlatt.
Thank you,
Schlatter.
Judge Elrod. I want to address the subject matter
You're
jurisdiction
muted.
issue first.
There you go.
That was not raised in the district
Thank you, Your
court.
Honor. May it please
which
the
would
court.
explain
My name is
why
Steve
the
Slather, and
subject
I'm
matter
representing the
jurisdiction
appellees
issue
here.
sort of evolved
I think
later
a
in
brief
briefs.
background here will be
The
helpful
district
to
court didn't rule on it
understand
because,
the
again, it wasn't
context of the
raised
settlement agreement.
in the briefs.
But we
Mr.
have to
Wright,
consider it, don't
one of
we?
the
Yes, ma'am.
defendants and appellees,
That's absolutely true.
is,
And as
was
referenced
the
in the
developer
briefing,
of the technology
we're
that's
traveling under the
kind of
Tucker
at
Act.
the
The Tucker
center of
Act is
this.
concurrent jurisdiction over the
He
CDA,
founded
which is the
Polyflow. He was the
Contract
CEO
Dispute
for a
Act that,
time,
Counsel
developed
referenced.
its products during that time.
As long as the claim is under $10,000,
At some point,
we can
the
travel
parties
under
went their
concurrent
separate ways.
jurisdiction
Mr.
issue,
Wright
and that's,
set out to form Specialty
28
RTP,
USC
where he
1346,
remains
which is
today,
the provision
and
under
Polyflow
the
continued
Tucker
with
Act,
its business.
subsection
You've
A2.
seen reference, and
Now,
we discussed it in our brief, that
the reason why
in
that
2015,
gives us
Polyflow
jurisdiction to consider
brought
our contract
claims
claim
against
the Marshals
Mr. Wright
Service
and
is because Mr.
SRTP.
Davis is
And
not
in
a
fact,
contractor.
those claims are
CDA does not apply,
largely the
so
same
under
claims they bring now
1346,
in this case.
It's reference to the
That suit
procurement
was
provisions
ultimately resolved.
as accepting
It was
the Will Tucker Act's concurrent jurisdiction.
really best described as a nuisance suit,
does not
and that's
apply,
evidenced
and
by the
it's
fact that
therefore saves as a
if
matter
you look
of
at the settlement
perspective from
agreement, no money changed
1346.
hands there.
That is, it's concurrent
The
jurisdiction.
part of that
over the
agreement
contract claim
is
is
sections
preserved.
B1 and
Again, because
B2, and those
Davis
put
is not a
restrictions
contractor.
on
He's an employee of a contractor.
Specialty RTP
He's
with
also
regard
suing
to
in his
what
capacity as
information
employee of
it
the
can
Marshals
use and
Service.
what products it could design
so,
or manufacture.
It's again a
Mr.
claim,
Wright and SRTP have never
not
used
by a
Polyflow
contractor.
information, but the
It's a
agreement
claim by
provided that there was a
employee of a
mechanism
contractor,
for Polyflow to
or it's a claim by an
confirm
employee
on
of
an
the Marshals
ongoing
Service under
basis
joint employment
whether
theory.
any of
So therefore, the CDA
SRTP's
doesn't
products
foreclose
did
jurisdiction. We
include
have the we
polyflow
can look
information
elsewhere for jurisdiction
of
that's under the
particular importance
1346
to
provisions.
specialty RTP was the dispute resolution framework set
Reference
forth
to
in
Mr. Davis
sections
as the
B4 and
contractor's
B5 of the
representative,
agreement.
the
And what
contractor's
those call
representative,
for is the
incorrect, and
appointment
it
by an
also,
arbitrator of
does
what's
not,
referred to as an RTP expert or a
adequately
neutral pipe
explain
expert.
or
And that
reference
was a
contract provisions
person that
to
was
the extent that they talk about
neutral
the
and
district
also
supervisor's
knowledgeable
role
about the
in the
technology
administration
and
of
the
the
products
contract.
that were involved from both Polyflow
if you
and
look at the same section that
SRTP.
Counsel
And
referenced,
that framework
in the contract,
requires
section
that the
C3.4,
pipe expert examine any
states that
products
the
that
the district
specialty
superintendent or
RTP
supervisor shall serve
intended
as
to
the primary
manufacture
point of contact.
or design for a
doesn't
time
reference
period
that
and make a
it's
determination
acting on behalf
of whether
of the contractor.
those
But even if
products
it did there,
violated section
we can
B1 or
construe that,
B2 of the settlement agreement.
Iqbal
And the reason
Twombly
this
way,
framework was
which
set
I
up
think
this
is
way and the reason
contrary
that
to
there
what
was
the
a
standard provides,
neutral
but there
expert
are other
put in place
provisions in that
was because
section that clearly
specialty
delineate
RTP
the
was
fact that the
particularly
district
concerned
supervisor acts
that
under the direct
Polyflow would
supervision and
use
control
this
of the
mechanism
contracting
to
officer, which is the Marshals Service.
to discover or learn
So
about
why is Walden
specialty
still in this
RTP's
case?
technology.
Well,
And
Walden's
so
in this
that's
case
why they
because
had this
of the,
neutral expert
again,
in
under the
between
joint
so
employer
that
theory,
neither party's proprietary
I'm not
information
advocating
would ever
that
be
they suffer the
shared
sins
with
of
the
their
other.
father
It would all go
in
to the
that
neutral
sense, but,
expert. He would make a decision.
If we can show under
and,
the theory,
the information would
under the
remain
Burton case, which is cited,
separate from the
that,
other party.
Walden was aware of the retaliatory
Going forward,
action that we allege.
The pipe
and
expert,
failed to
once he
take
made a
steps
decision, and as Ms. Stratton noted,
arrest that,
if the decision was in favor of specialty RTP,
joint employer gets us
pipe
halfway there,
expert's
but not all the way.
decision was final.
We have to show
Only
and
if
reallege
he found that
that there is
specialty RTP was in
some
violation
complicity there.
would it then
We
trigger
tried as a matter of discovery.
a mediation
We asked
process,
Walden,
and the pipe expert would attempt
in a
to mediate
deposition,
that dispute.
And of course, from
And
their version,
only if he was
they were
unsuccessful
not
in
aware of
mediating
the
that
specific
dispute,
reasons
would
they
the
heard
parties,
things
did the
through
parties then
grapevine
agree
Mr.
to take
Davis not being
that
qualified,
dispute
or that there was
to
some
arbitration?
unalleged
And that
incident,
is the
I think is what the
arbitration
deposition testimony
provision that
was.
you see
But it didn't
in
get any more
section
specific
B5
than
of the
than
agreement.
that, and it was
It
not
is specifically
formal, it was
related
informal
to
grapevine
these
talk.
disputes
We asked
that
the
may
Marshals Srv
arise in the
for their
context
version,
of the neutral pipe
and we wanna
expert
know all the
and sections
communications,
B1 and
went back and
B2
forth
of
with
the
Walden
agreement.
about
But
Mr. Davis's
the
termination.
important part of that is that
We were
the
still,
purpose was
the
to
best thing we
prevent
got was an
specialty
opportunity
RTP's
to take a
technology from
deposition
falling
on
into
questions of
Polyflow's
an
hands
individual,
under the
and that
guise of
deposition,
policing the
according
agreement.
to Marshal Service's
The
limitations.
second
were
arbitration
offered
clause
on the
here
deposition was
is
limited to
found in section
communications
C4. It relates
that
only
individual
to
engaged in with
disputes that arise
with Walden,
under the
with
agreement.
You need to wrap it up,
And
Mr.
that's
O'Donnell.
very
Your
clear
time
as
is
well.
up.
And
Okay,
I think
well,
on that
would be
point,
it.
the courts are clear, including in the Pennzoil case,
I think we've
that
addressed all of the main
an
issues in the
arbitration
case, and I
clause
appreciate
that
the court's
uses
attention.
language such as
Thank
arising
you.
out of
We appreciate all
is a
the
narrow
arguments
clause.
today,
And the
and
court
this
in
case is
Pennzoil
submitted.
contrasted that
Thank you.
with broad clauses that use language such as arising out of or related to. That's clearly not what we have here. Under Pennzoil, the clause in C4 is a narrow one. That's further evidenced by the fact that the clause in C4 does not even cover all disputes that would arise under this agreement, because it's, as I mentioned, the separate dispute resolution mechanism set forth in section B5 would cover disputes that fall under sections B1 or B2 of the agreement.
Well, I might agree with you if the arbitration provision in B5C said anything about limited to this agreement or this mechanism, but instead it says, for purposes of clarity, the parties are agreeing that any disputes arising out of or related to this agreement will be arbitrated. And aren't we, since and going a little further, aren't we required to interpret these provisions harmoniously and not one limiting the other or being limited arbitrarily as opposed to the other one. Go ahead.
Well, I think they do need to be interpreted harmoniously. I'm sorry, Your Honor. I think they do need to be interpreted harmoniously, and I think the way that that is done in this case is that you look at the agreement as a whole, and specifically in sections B4 and B5, it sets forth this dispute resolution framework that relates to as I mentioned, the neutral pipe expert and his duties to resolve disputes arising under sections B1 and B2. And then if you look, C4 then would cover anything else. And so otherwise you would, if you read section B5C broadly to cover all disputes that arise under or relate to the agreement, you end up rendering the clause in C4 a nullity. And that's what the parties intended here was that agreement or that clause in B5 would relate to the dispute resolution framework of sections B1 and B2, and that C4 then would cover any other disputes that arise under the agreement.
Well,
so with regard to
what's your best case? What's your best case?
With regard to
you and I, your transmission is a little slow. I'm sorry, I don't mean to interrupt you.
I apologize, and I don't. It does drop occasionally, and I'm not sure why.
Well,
I think just the plain reading of the agreement, as you mentioned, requires those two clauses to be harmonized, and the agreement itself makes clear how to do that, because it sets forth the framework for dispute resolution under B1 and B2 in sections B4 and B5. As I mentioned, where you have two competing clauses, and in this case they don't compete. But if you did try to read them on top of each other, one would just be rendered a nullity, and that shouldn't be the right result here. Further, I believe I understood Polyflow to say that they are seeking arbitration solely under C4 in this case. With regard to the argument that all claims, if any claim is arbitrable, all claims are arbitrable, and that's Polyflow's argument with the Archer case. Here again, the agreement makes clear that certain disputes, those arising under B1 and B2, do not fall under the arbitration clause in C4. And so at least one category of claims would not go to arbitration, even under that, or should not go to arbitration under Section C4. That's not what the parties agreed to. They agreed to have two separate arbitration provisions covering different aspects of the agreement.
So is it your position that you want part of this dispute arbitrated and part of it submitted to the federal court?
Well, we believe all the claims should properly remain in front of the court, and that none of them are arbitrable. And
well, you just said that B1 and B2 are arbitrable.
They are if and that goes to whether certain conditions are met, and as we describe in our briefing, those conditions just simply haven't been met. There's a framework, and it requires the the appointment of an MPE by an arbitrator, that was done. And it requires the pipe expert to then examine SRTP products to see if they are in violation of sections B1 or B2. He's done that. In this case, he has not found a violation, and therefore, under the terms of the agreement, that's the end of that inquiry. However, if there was a case where he found SRTP to be in violation, only then, if he was not able to mediate that dispute, would that specific dispute go to arbitration under the provision in section B5.
Well, I mean, they assert that a number of their claims, they assert
in that way, then.
Okay, I'll try again. They assert that a number of their claims are based on disclosures of information contrary by specialty RTP, contrary to the settlement agreement, interference with customers of Polyflow, and Lanham Act violations. And it seems to me all of those are reasonably read as being governed by the settlement agreement. So why are they not arbitrable under C4?
Well, if we look at the Ford case, for example, the test for whether tort claims arise or relate to the agreement is whether those claims could stand alone. And so certainly the Lanham Act claims, which relate to trademark and trade dress, largely, those claims could certainly stand alone here. The existence of the agreement is not required to go forward with those claims. With regard to tortious interference, it's the same. The activities that Polyflow complains about which was disclosing information to certain customers, setting aside that may not even fall under the Lanham Act because it doesn't relate to goods or services, that cause of action would stand alone. It does not require the existence of the contract. And the same is true with regard to the fraudulent inducement claims. And that's, if we look at the Ford case, it addressed fraudulent inducement, Lanham Act claims, and tortious interference claims. And in each of those instances, it found that they did not relate to the underlying agreement and did not require the agreement. And in that way, they stood alone and were not arbitrable. And I will point out in that case, that was a broad, that did involve a broad arbitration provision that covered any claims arising from or related to the agreement, which is not what we have here. We have a narrow provision that only covers claims that arise from the agreement. And so with regard to Lanham Act, fraudulent inducement, tortious interference, they simply just don't arise from the agreement. They stand alone under Ford.
Why is it that your client decided not to do arbitration?
Polyflow has asserted in this case a number of claims that it previously released in the earlier case. And we've provided a comparison of those claims, and you'll see that they are, most of them are largely identical. And in fact, in the first amended complaint, Polyflow makes clear that it's relying on activity that occurred before the settlement agreement. And that's at record 1203 and 1204, where it specifically sets out before the settlement agreement, and then provides a kind of laundry list of bad acts that it claims SRTP is guilty of. Further, in the counts themselves, it refers to activity involving Exxon Petronas. Both of those companies were part of the 2015 loss. And so we don't want a case, and we think they should they should be resolved in federal court, not in front of an arbitrator. They simply do not arise out of this agreement. I mean, if we look at what the parties agreed to arbitrate, and that's really the focus here, what did the parties agree to arbitrate? It's very clear. They agreed to arbitrate only those disputes that arise out of the agreement.
And that's so, the word is action.
The word is action, and in this case, we contend that action means a claim or a cause of action. And we have addressed the Archer case in our response to Polyflow's supplemental authority, and that's further underscored by the party's definition of a claim in this case, where it defines claim synonymous with action, where the parties wanted to refer to an entire litigation. They did so. For instance, they referred to the 2015 litigation, or they refer to it as a civil action. In this case, action should be construed to mean cause of action, and that's further underscored by the fact that to read action as the entire action in C4 would then render any claims that arise under B1 and are required to be arbitrated, perhaps at some point under Section B5, it would render that a nullity, and that shouldn't be the result here. Going back to two issues, with regard to the release claims, I understood Polyflow to argue that is an issue for the arbitrator. It's simply not. In this case, those claims, the released claims that are now included in Polyflow's current complaint were released in the same agreement that the arbitration clauses are found. And so that is not, those claims are not something that the parties agreed to mediate. It perhaps could be a different result if the release claims were in a different agreement or something along those lines. But here they were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate them at some point in the future. With regard to the failure to mediate, the framework in Section B is very clear that if Polyflow believes that SRTP is in violation, it can raise that issue with the neutral pipe expert, and then he will go forward with his analysis and mediation if necessary to resolve the dispute. SRTP has complied with every request from the pipe expert with regard to providing products. So for examination, products and information. So to the extent that Polyflow claims that there are products that it believes are in violation, but SRTP has not turned over, that is the result of Polyflow not raising that issue with the neutral pipe expert in the first instance. And I see I am out of time.
Yes, sir, you're out of time. We'll go back to Ms. Stratton for rebuttal.
Thank you, Your Honor. I'd like to begin with the issue of mediation. You've heard opposing counsel describe their view of why mediation was a prerequisite here, and we obviously vehemently dispute that. And that's precisely why the issue is not clearly established such that this court could decide it, because no rational mind could do anything but agree with Mr. Schlather's position. He's not articulated why it is clearly established and essentially undisputed here that a procedural prerequisite was breached. So all of his arguments about what should have been done in the mediation process, that's all for the arbitrator to decide under this court's procedural arbitrability precedents. I'd like to also briefly discuss the issue of release. Appellees appear to be trying to take the issue of release and frame it as a question of what the parties agreed to arbitrate, a question of substantive arbitrability. But this court has made clear that it does not consider the merits in its substantive arbitrability determination. You said that in Chevron Chemical, you said it in Bank One v. Hill, and in numerous other cases. And what Mr. Schlather's argument does by asserting release as a question of the scope of the arbitration agreement is inject the merits into the substantive arbitrability determination. For this court to decide whether Polyflow released or sued on released claims, it would have to resolve the merit. That is a basis for Polyflow's counterclaim in this case. That's not properly before the court in a substantive arbitrability analysis. Release is a defense. That's how this court should treat it. And that's exactly how Mr. Schlather's answer on behalf of Specialty RTP in the district court treated it, as an affirmative defense on the merits, a basis for their merits counterclaim, and therefore it's properly submitted to the arbitrator as part of the underlying merits of the dispute. Now, I'd like to move on to addressing the interaction between C4 and B5. There is a way to harmonize these provisions, to read them quite naturally in a way that doesn't treat them as two separate arbitration provisions or treat them as a limitation on one another. First, there is nothing in the text of either C4 or B5C that suggests that they apply to anything other than the entirety of the agreement. There is no limiting language, as Judge Jones noted. And the most natural reading we submit of B5 is that it is inserted to protect the breadth of the parties' arbitration agreement, because it appears in a section laying out certain procedures for resolving certain types of disputes under the agreement. And it heads off the potential argument that by laying out those procedures, these were the only substantive claims the parties intended to arbitrate. And so the text of B5 says very clearly, for purposes of clarity, we are clarifying that we are agreeing that any dispute arising out of or related to this agreement shall be arbitrated. And so in C4, you have an extraordinarily broad arbitration provision. In B5C, you have another extraordinarily broad arbitration provision, and broad plus broad equals broad. It does not, as Mr. Schlather contends, equal narrow, and it does not equal arising under, which is what he said at the beginning of the argument, that we agreed in C4 to arbitrate arising under. This court made clear in Explo that arising out of and arising under are not the same, and that arising out of is a broader arbitration clause than the more narrow arising under. It's Mr. Schlather's burden to furnish this court with positive assurance that this arbitration agreement cannot be read to cover this action. And in order to meet that burden, appellees have had to rewrite the arbitration language to arising under and call arbitration clauses that this court and others have repeatedly called broad narrow, insisting upon that. And our opinion, Your Honors, is that that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies upon. In Ford, the court made it clear that when a tort claim is based upon a breach of contract, it's arbitrable. There was no breach of contract claim in the case. The parties could have completely complied with their obligations under the contract, and the tort claim in that case would still have proceeded. That's why the Ford court was able to say, this contract is legally irrelevant to this tort claim. We can treat it like it doesn't exist. That's not possible here. For example, Mr. Schlather asserts that the Lanham Act claims have nothing to do with the settlement agreement, but I'd refer the court to paragraphs 96 and 114 of our unfair competition claims, which are based specifically upon appellees' misrepresentations about the terms and scope of the settlement agreement itself. The fact finder simply could not resolve those claims without consulting the terms and scope of the settlement agreement, and they arise out of the contract. Thank you.
All right, thank you very much. That concludes our brief hearing for today, and we'll take the case under advisement.
Thank you.